Hello, I'm Mark Ryan, and I love talking about anything 8A and government contracting. Today I'm going to talk about size standard and an important case that took place last year and how it may be affecting how the SBA calculates size standards. So let's get into it. So for a long time now, since March of 2018, this has been pretty straightforward. The SBA has stated that there is no authority to consider any evidence apart from tax returns when calculating a firm's average annual receipts. So basically, you can take your last 5 tax returns, add them together, divide it by 5, and that's your annual revenue. The only exception they've had for that is that if the tax return hasn't been filed yet, that you could use the company's financial statements, the company's P&L for that period. So pretty simple calculation. In May of 2023, the U.S. District Court of D.C. made a ruling that this is not necessarily the case, that contractors have to take into consideration other information than their tax returns. And I'll come back to why that's so important here in just a moment. Let's first understand what the size standard means. So when you're doing government contracting, you can go onto sam.gov and claim to be a small business. So you make an indication on there that you're a small business, meaning your revenue is below the size standard for your industry. Let's say 34 million if you're an IT consulting firm. So that's that 5-year average. And that comes into play with a lot of certifications as well. Certainly the 8A certification, the small disadvantaged veteran-owned small business, the veteran-owned small business, the economically disadvantaged woman-owned small business, the woman-owned small business. So all those certifications require you to be this small business. So in this case, we had BidSolve Inc. protesting that CWS was not a small business. CWS had taken just the simple average of its last 5 tax returns to establish it was a small business. We don't know how BidSolve knew that wasn't correct, but what we do know is that BidSolve had a reason to believe it wasn't. I presume they went to usaspending.gov or to the data bank and looked at the 5-year average of their government contracts and had reason to believe that it was a misrepresentation. But we don't know what brought BidSolve to this conclusion. Ultimately, they protested it and were able to get the U.S. District Court to agree that CWS was not small. So the logic CWS was using is that they were reducing some pass-through incomes from their revenue and basically not counting all their income on their tax returns. Once BidSolve was able to establish this, the court made CWS add that income to its tax return and came back with the conclusion that they were not small. Now, I'm overly simplifying it because they actually had to do it through a False Claims Act and there's some back and forth. But the point is, the ultimate conclusion is that the court has now set the standard that the SBA, when calculating size standard, cannot just use tax returns, if there's some evidence to the contrary. However, that was May of 2023, and almost a year later now, the SBA has still not incorporated that into their regulations. My quick takeaways from this. First off, we can expect the SBA to ultimately update their regulations to incorporate this U.S. District Court precedence. Whether they do or don't, the precedence is still out there though. And whenever you're calculating your size standard or looking at the size standard of a competitor, it's important that you don't just take your 5-year average tax returns, but you also take into consideration if there's any revenue that was left off your tax returns and whether or not there's a justification for counting that as part of your revenue. That's it for this update. Of course, always feel free to reach out with questions. Thanks.